Cove Productions presents the Solo in South Philly podcast with your host and local legal whiz, with knowledge, Mark Kachi.
What's good, everybody? Welcome to the Solo in South Philly podcast. Our season 1 is called Law School Reunion. It is a remix with the homies from the Midwest side. Each episode, I will be reuniting with a different law school colleague. We will discuss what led them to law school, their law school experience, and what they do now. My guest today is Michael Jean. Michael Jean is the director of the Office of Litigation Counsel at the NRA, the National Rifle Association Institute for Legislative Action. He's responsible for advancing NRA members' interests through litigation and advocacy. He has brought numerous suits vindicating NRA members' constitutional rights in state and federal courts across the country. He has also successfully challenged and intervened to defend federal hunting regulation. And he serves as a liaison between the NRA and several other hunting and wildlife management organizations. He received a Bachelor of Arts degree in Criminal Justice and American Public Policy from Western Michigan University. He went on to law school at Western Michigan University Thomas M. Cooley Law School. He was also a guest law student at the Monash University Law Faculty in Melbourne, Australia, University of Canterbury School of Law in Christchurch, New Zealand, the University of Toronto in Toronto, Canada, and the University of San Diego's Paris Institute on International and Comparative Law in Paris, France. He clerked for the Criminal Division of the 3rd Judicial Circuit Court of Michigan in Detroit and finished law school as a litigation intern at Safari Club International in Washington, D.C. I had the pleasure of meeting Mike during study abroad in Australia and New Zealand. And during that time, we were fortunate enough to have some long weekends and breaks. So Mike joined me and some others as a last-minute addition on an excursion to Tasmania. We've become good friends ever since. I think I lent Mike my copy of Jeffrey Toobin's book, The Nine, about the Supreme Court during a New Zealand trek. So I like to take some credit for his ventures into constitutional law. Since graduation, Mike moved to DC with nothing other than his willingness to work, and he has since graduated to the level where he has bona fide haters on Twitter. Now he's involved in some key litigation, and he's flying around the country to teach CLE courses. So I'm really happy to have Mike on the program. Welcome, Mike.
Hey, Mark. Thanks for having me. It's good to see you.
Good to see you as well.
And you did lend me that book, by the way, so you can take all the credit for my success.
Yeah, I remember we had lots of spare time on our hands, so it was great. We're walking through the Abel Tasman track, discussing different constitutional law theories. Pretty fun stuff.
Lo and behold, here I am, a constitutional litigator.
All right, so let's talk about life before law school. You're from Michigan, outside the Detroit area, right?
Farmington Hills, Michigan.
And why don't you tell me about life before law school and what led you to law school?
Yeah, so I kind of grew up without a lot of guidance as to what I should do. And it was kind of like, I describe it like the pull method for an assembly line, right? When you run an assembly line, you have what's called a pull method. That means if you're the next guy on the line to me, I get my part to you whenever you're ready to have it. So you're pulling the things forward. There's no push, so there's no log jam anywhere. And I kind of just went through high school and it was always just assumed that I was going to go to college, but I didn't really know what for. Then I ended up at Western Michigan.
Row the boat.
Yeah. It was kind of random how I ended up there. But went through there, graduated, and then you get to that phase, you just graduated. Now what? I didn't really know what I was going to do. I had a very sick grandma at the time. She was actually one of the oldest ever known living people with her disease. So I had to take care of her for a little while. But then she got to the point where I really couldn't do that. She just needed a lot more professional care. And while I was doing that and working odd jobs, I think I read it in Bill Clinton's memoirs where he talked about going to law school and how that was a good choice because you would always have something to fall back on, even if you couldn't make it in whatever else you were doing. And that sounded interesting to me. I had some political philosophy classes in undergrad. I was a criminal justice major, so it seemed like it kind of fit. And that was, I think, the one time where I finally at least took some ownership or some control for what I was doing, and went ahead and took the LSATs and went ahead and went on to law school.
Yeah. So let's talk about that a little bit. You said limited guidance, as I know you personally. So you're not an only child, but your siblings are significantly older than you, and your mom was working and supporting the family. So you were kind of left on your own to figure out life, right?
Yeah. My next closest brother is 14 years older than me. So I'm not an only child, but I grew up as an only child. My mom, she worked for the United Auto Workers, and she had her own business on the side. So she was out there really hustling. I didn't have a father. He passed away when I was 6. So I was just kind of left to my own to figure things out.
Yep.
And, in growing up in the Detroit area, it's always like, yeah, you'll figure it out. Go work at Ford's. You say Ford's with an S, or GM or something like that. But that's kind of what happens. I think, at least it used to happen to people without a lot of guidance growing up. But I think I grew up in the era where it was college, college, college. That's what you're going to do. So, but for that, I think I probably would have just, ended up working some job in Southeast Michigan somewhere.
Right. So let's talk about the LSAT, because I know that a lot of people that went to Cooley went there because it was their only choice, and it gave them the opportunity to get there. If I remember correctly, you did really well on the LSATs and got into schools that were ranked higher than Cooley. So first, let's talk about how did you do so darn good on the LSATs?
Yeah, well, that was the first time, like I said, I took control over some things, and I took a Barbary class, or not a Barbary, Kaplan was for LSAT, I think. Studied pretty hard in there. The first LSAT practice test I ever took, I did horrible on because I didn't understand the time concept to it about how fast you need to answer those questions. And I was just trying to think my way through them. I was getting them right, but it took forever. And, I think the test was done and I was only like a quarter of the way through. But then you go to take that class and they kind of teach you the hacks for how to speed through it and work your way through it. So that was one thing I learned. The second thing I learned was your mental endurance for a long test like that. Before the LSAT, like 3 weeks before, I was getting up at 5 o'clock and taking a full practice test just so I would have mental stamina. I would not get tired at all through it. And did that, did fairly well on it. Cooley offered me an 85% scholarship. So I did the math, and, it was like $12,000 for tuition versus all these other schools. Cooley would also let me start in January, whereas I would have had to have waited till September to start everywhere else. And Cooley had a study abroad program, and I think that's something I was very focused on. My very last term of undergrad, I was getting ready to graduate, and I came home for Thanksgiving, and my mom asked why I never studied abroad. And I said, I don't know, I was working the whole time. I was just going to school. It never came up. And so she said, you should have done that. So we pushed my graduation back like a semester so I could go to Spain.
Oh, wow.
Picked up credits I didn't even need. But then I kind of had like the travel bug, and I saw that Australia, New Zealand opportunity at Cooley, and I just jumped on it. And I didn't really think about you know, the institution, other schools, anything. That's just where I was going to go.
Yeah, couple things there I'd like to go back to. One, the LSAT. So maybe I had you misread. I thought you were someone who liked to do Sudoku and puzzles or something and just had the spatial intelligence and like got all the logic games really well. But it sounds like you actually made improvement. What caused this breakthrough? Was it the time management and things? Because like I know they would teach you little hacks you mentioned. I remember they would say, when you run out of time, pick the same answer consistently down the board. And then they even had statistics that said like B, for example, is the right answer 23% of the chance times as opposed to 17. And that could be the difference of 1 point on the exam. So was it just time management, or what sort of breakthroughs did you have, if you remember?
It was time management. It was little hacks like, I remember one practice question I got wrong and it infuriated me. Like, Billy has a meeting at the UN at 2:00. The only flights to New York from where Billy is get him there at 3:00. Billy will miss his meeting. And I said, yes, that's true. On the LSAT, it's wrong because they didn't tell you the UN was in New York, even though it really is there in real life. So,
oh, wow.
Yeah, that question, I think, just learning, okay.
So you learned about judicial notice before you even went to law school, right?
Yeah, forget everything else you know. And then the other thing that I learned with the games was, like, I was kind of mapping them on my own, but there's a way to map them specifically. And there's the horizontal one that everyone seemed to do. I couldn't do the horizontal one. I did it vertically every time. And I don't think I got a games question wrong on the LSAT because I learned to map them vertically and it just worked for me.
That's great. That's great. And then about study abroad. Yeah. Such an important opportunity for a variety of reasons. And you mentioned choosing Cooley for that reason. I would say that's probably the predominant reason I didn't transfer from Cooley. A lot of my good friends were transferring and going to higher ranked schools and interesting places and schools with Division I programs. And there was always that draw, but there was this possibility that I could spend the same tuition and during a Michigan winter, go down to the land down under and have some fun there, learn some law and experience a new way of life. So I think it's something great that our school has a great program that they have created. And they even brought in people from other schools to join us, some guest students that made great friends with us, that meshed with us really well. But I agree with you. You would agree that it was worth the decision that you made, right?
Oh, it was so worth it. I went twice.
That's right. That's right. You really took this and ran with it because you went to Toronto and then Paris, right? Through a different university?
Yeah. So I was sitting in class in Australia one day thinking about how, this is cool. I don't want to go back to your standard law school classes in Michigan. And I was on Facebook, I think, and found other friends that were going to go somewhere in the summer. And I just said, hey, where are you guys going? They all went to Paris. And I was like, well, Cooley has a split summer program where I can go to Toronto for, 6-7 weeks or something, and then go meet you guys in Paris. So that's what I did. And I think that year I flew to Australia, I want to say 2 days after Christmas, got back, was home for about 2 weeks. Then I took the train to Toronto. I was there for 6 weeks. Then I flew to Paris, was there for another 6 weeks. And then I had another month before I had to be back for the fall semester. So I trekked across Spain with a backpack.
Yeah, you did the Camino Santiago, right?
Yep.
So I missed out on all that fun. Tell me about what it was like studying abroad in Toronto in Paris.
Toronto was very similar to what it was like in Australia.
Because it was a Cooley program, right?
Yeah, it was. The grading was softer though, and there was also a lot more interactions with the professors after class. So we would be going to the bar with them and hanging out. That didn't happen in Australia.
Which professors came to Toronto?
John Brennan was there.
Okay.
The other professors
John Brennan, he was the founder's son, correct?
Yes.
Okay.
The other professors they brought in, we had this guy named Murdoch, who was a big-time NAFTA lawyer in Toronto, and another professor named Blackbranch, who I want to say he was at Oxford.
Okay.
He did his PhD at the University of Toronto, so he just found a way to come back and hang out in Toronto for a summer. But Blackbranch was the one who, we were at a bar one night, like the week of exams, and he just pulled me aside and said, "Hey, how does this sound? Everyone gets a B. If it's good, people will get an A. And if it's bad, you'll get a C. And if you don't show up, you fail." And I was like, I think that's fair. I think you should really go with that. So I randomly negotiated the entire class's grades.
Wow.
At a bar somehow.
Very good.
I don't know why he picked me. That just happened.
And what was Paris like?
Paris was a lot different because there I was a guest student through the University of San Diego in their program, and it was not at all predominant. I wouldn't say the others were predominantly Cooley, but they're probably 50% Cooley students. Mm-hmm. There it was much different, and the one thing I remember is that no one else participated in the class. And I was never one to participate a lot. I would just get really annoyed that things would kind of stall out and not go anywhere when the professor was looking for an answer. He's like, "Okay, I'll wait." And then I would jump in. But it seemed like I was doing that all the time in Paris.
So did these students have their laptops open and they were firing away on the chat bar to other students and on Facebook?
Yeah.
Wow. Yeah, that's one thing that Cooley really instilled in us was, especially in our first year, you had to come correct to class. They could call on you at a whim. And, some professors would go Kingsfield style on you in terms of the Socratic. So people were really nervous their first year going into class, having to stand in front of everyone and delivering. So
yeah, and it's your first year, so you're obviously not good at it either.
Right. And the true Socratic, you're never right either. So you need to understand that concept that even if you get the answer right, it's, well, let me switch around the facts a little bit, and then what would the answer be? And why are you right? Oh, well, you didn't get that answer for me. So it's a beautiful thing as you learn to think legally. So we talked about life a little bit outside of Michigan. What was life in Michigan like at the Thomas M. Cooley Law School? What was your first year like? That sort of thing. Were you scared about failing out because we have we had a pretty large population of students that don't make it after their first year. So what was that all like for you?
My first year, I didn't really like it at all. I remember thinking I made a big mistake coming to law school and that it wasn't for me. But I somehow made the dean's list my first term. In that first term too, you have that intro to law class, mm-hmm. and where they kind of teach you how law school works. I remember on my first essay in that class, the guy wrote, he was a lawyer for the Service Employees International Union teaching this thing on the side. He's like, "This is really good. You're at the top of your class here with the way you're handling this." And I thought, well, that's weird, because I have no clue what I'm doing and I'm kind of just making this stuff up as I go. Again, you have the midterms your first semester too, and that's the only time they give them to you there. And I think on one I got them all right, which I found to be very strange too, but I really did not like the process at all.
As far as your essays go, here's my theory on that. You probably would agree with me. I would say you're blunt and to the point, right? So in undergrad, we learned to write these flowery essays and all this prose, but bar exam readers, judicial clerks, all these people, they don't have time to sift through all that. They have this checklist that they're looking to check off. So I could see you getting in there and just like, this happened, this is the law, this is the conclusion. Whereas other people are going off track and this and that. You were just like succinct and to the point, and that's what made you stick out.
Probably. And if that's happened, that's because my history 210 professor at Western Michigan, he drilled in this point about when you write essays on his test, he's like, I want the 3S method. You give me a statement, you support your statement, and you tell me the significance of it. So that's how I learned to write, at least from him. And maybe that carried over there. I haven't thought about it. Yeah. But it probably did.
Yeah, I know a lot of people say that they had to relearn how to write when they went to law school. So I think that professor might have done you a solid. So, okay, so you did well grades wise. What about like, did you like it socially? Did you like the atmosphere? Did you like the environment? Did you like your classmates?
I was a hermit my first term. Never went out once, just hung out with people in class. And that was probably about it. Made some more friends later on and became more social afterwards. And then, of course, in the study abroad programs, it's all just a close knit group who just hangs out. But returning from that, I think I then stayed more social with some of the people I met. But I don't think I hung out with people all that much, though. I think I was I kept to myself a little bit more than most.
Gotcha.
And I still do to this day.
Okay. Any advice for people going to law school?
Advice for people going to law school? A lot of people say going to law school is a good option because there's a lot you can do with it. I think that's terrible advice. I think there are a lot of people who went to law school and realized they don't want to practice law, so they're in other areas. But going to law school just to get a degree that you can do a lot with, I think is a very bad decision to make. And it's because you're spending 3 years of your life learning a very particular field in that, law school's kind of centered around the casebook method, which Harvard invented during the Civil War era. So it hasn't really, gotten modernized that much. But, you're going to spend 3 years learning the Fox case and all these things that don't really translate much into other fields. John Cooper is an example. He won a couple Stanley Cups with the Tampa Bay Lightning. He went to our law school. I mean, do you think it really prepared him to be a NHL hockey coach? Or he probably could have spent those 3 years doing other things that would have better prepared him. So that's my advice to people going to law school. Really think about why you're going and what the practice of law is. And if you're not sure you want to do that, it's probably not the best option. That being said, maybe you find out it's a good option for you later on and you may have success. But
See, I definitely see what you're saying, and I think that's definitely, I understand your advice. That's a great point. And we could go on for days of people that you didn't know have a law degree. Chris Collinsworth has a law degree, right? Geraldo has a law degree. All these people have law degrees. I think subconsciously, though, it prepares you for a lot of things that you don't really realize, because like Chris Collinsworth talks about how he prepares for example, he prepares for each broadcast like he does for a law school final. He has this mountain information, he funnels it into an outline, and then he's ready by game day to rattle all this stuff off. I find in the workplace, there's like just learning the way that these justices write and these concepts, you can get your point across so effectively. And you may not realize that it was law school that taught you how to do these things. I can't think of the perfect example in my head right now, but yeah, I mean, I know what you're saying. It's a lot of money. And if you have no interest whatsoever, you may want to consider a different option.
If you're doing it to check a box, it's probably not worth it.
Right.
But even Chris Collinsworth, I could push back and say he could have learned those preparation skills elsewhere, probably at a fraction of the cost, and would probably learn preparation skills that are better and suited towards broadcasting than he would, spending a week learning property law and what happens when Red Acre gets granted to B, as long as it's used for supporting B in law school and all those questions.
Sure. Okay. So let's talk about the end of law school. You went to DC to do your externship there?
Yeah. Then I finally got caught up with myself. I went to DC. I was clerking at the pro se unit of the United States District Court for the District of Columbia. I lasted about 3 weeks before I got fired.
And you got fired from an unpaid externship, which was work you were doing for free for the entity, and in exchange, Cooley would give you credits for it, correct?
Correct. And that's kind of where I figured out, I skated through law school because I didn't really like it, but I would do well on the exams. Then when you get out to actual practice in the federal courts in DC, you're in a whole other level, and you can't just rely on showing up to an exam and passing. It doesn't work that way. And I think that's another thing I learned is, the way law is practiced in federal courts is a lot different than the way we learn civil procedure. It was a lot about personal jurisdiction and things of that nature. But when you have these pro se people bringing these claims, nothing's spelled out for you. You have to dig through it and try to figure it out. And a lot of them, one of the cases, a guy worked on the loading dock at the Budweiser factory in Missouri. He alleged that the Baltimore Ravens, Senator Hillary Clinton and Senator Bob Casey and several other people conspired to get him fired. And he was bringing this whistleblower suit against Budweiser. And I was like, well, this is nonsense. Let's just talk.
That sounds like a Family Guy episode to me.
Yeah. I remember another case where a guy defaulted on his student loans, and they reported that to the credit agencies, and he sued for defamation. And I was like, well, that's true. So just dismiss this. And then I realized that, you can't just dismiss things. They have a very specific process for how to dismiss something under Rule 12b-6. And you need to make a strong showing that taking everything is true. Taking everything in the complaint is true. there is no claim for relief here. And that's how Rule 12b-6 works. Didn't really have that understanding when I went there. I didn't really have an understanding that federal courts were pretty much run strictly by the federal rules of civil procedure, although it seems completely obvious to me now that everything you do there relates around one of those rules or the local rules. But that's one of the things coming out of Cooley that you didn't get. I think another thing that set me back a little bit is before I was there, I was clerking at the criminal division of the Wayne County Circuit Court in Detroit. And I was doing post-appellate relief for felonies, convicts. So these were people who had been convicted, they appealed, and now they were trying to get a new trial. And that's a hard standard to set. You really have to show a lot, like your counsel was ineffective. You have new evidence that you couldn't bring at the time of your original trial.
Right.
And so the attitude there was kind of like, these cases, they're all just going to get dismissed and we're going to deny these petitions. But going out to DC, it was kind of the opposite. So
right, because with the Michigan PCRA, I'm imagining it's this free appellate right that every convict has. Why wouldn't you shoot your shot? You shoot your shot, one in a small number, get granted, and you may get a new trial or may get exonerated, but that's not the same thing, right?
No, absolutely not. And I think of all of them, I only recommended the prosecution respond to one because I thought they miscounted on the sentence variables. But otherwise, it was just plain and simple to see that, these people had their day in court. They lost. They had their appeal. They lost. And now they're just, shooting from the hip and taking a long shot,
right,
to try and get a new trial.
So you didn't take it as seriously as you should, it sounds like, right? And that's why they let you go. Do you feel that was a favor to you? Did they ultimately do you a favor in doing that to you?
Yes. Probably the biggest favor anyone could have ever done for me. In that put me in a real jam because that was my last term of law school. And it was, people talk about law school, it's sink or swim. That was sink or swim. And I was probably, 10 feet underwater at that point. I was lucky enough to find someone who could place me in another internship where I got very great mentorship from a very experienced woman named Anna Seidman, who took me under her wing and taught me a lot. And I think working with her for 2 months or 3 months, whatever it was, I probably learned more than I did in the entire 3 years of law school.
Wow. So a little bit about the pressure element for those listening. This is what I think you're talking about. So you get a financial aid check or, your check to pay your tuition and your bills. It's already been allocated for that semester. And now you're 3 weeks in, you're not getting that externship. You're going to have to catch up in that limited amount of time, produce the requisite number of hours to get you your credits. Also that you don't have to worry about how am I going to get funds for the next semester. Is that where a great deal of the pressure was?
That, and the other pressure was, I spent the last 2 3/4 years, however long it was, in law school doing this, and I can't work for free. Where do I go from here? How do I figure this out? And I think I think the pressure actually helped in that one of the reasons I didn't like law school was it seemed like your professors were making these very complicated hypothetical problems out there just to see how much you knew. And they're testing you. That's what they're supposed to do. But, I remember one example where, a guy's on the roof of a building. He's going to jump off and commit suicide. And someone on a lower floor is having a fight with his wife. and he goes and just shoots a gun at the wall because he wants to make his point. That bullet goes through the wall and hits the guy jumping off the roof, and he goes down to the ground and splats. And it's like, what's that guy guilty of? And, it's a 1 in 10 billion chance that ever happens. Very, very unlikely. And it seemed like they were thinking of these crazy scenarios just to kind of show off. But when I got into that other externship, I was working on real cases with real consequences. That actually helped me, knowing that if I screw something up here, someone's going to suffer a consequence of it. So I think that really helped. And I think knowing that I had failed before really made me step up and do my best. It was a very weird situation there. The person that got me the internship just happened to be like the externship coordinator for Cooley. I don't know if you had one where you go do your externship and then there's someone who's kind of responsible for you. You check in.
Yeah, I did a clinic, so
yeah,
that was a little bit easier for that standpoint.
So she set me up with this other organization, and I went to a meeting on the Hill like the first week and just listened to, the House Subcommittee on Natural Resources and Wildlife, or whatever it's called, debate the Endangered Species Act and the fees provision, which just happened to be her pet peeve about fee provisions and how you can sue the government over procedural things and they'll just pay out attorney's fees. And she hosted a dinner for all the externs like the next week. And I was having a conversation with someone about what I had learned and how much I had paid attention to it and how I could describe, the way under EJA or some of these other fee shifting statutes, it's very easy to sue the government and get your attorney's fees paid out. And a lot of people out there just do that. And when I was having this conversation, she just cut me off and she said, "Michael, how do you know that?" I said, "I learned it this week." And she said, "You learned all of that this week?" I said, "Yeah, I just did." And she's like, "I'm going to write a letter to the dean at Cooley and say how the people who fired you were wrong. You have all this talent. It's unutilized," things like that. And she ended up being a mentor to me for several years after that. So, whether it's happenstance or whether I, showed up at the right time and did something good, it just happened.
That's great. So bar prep, what was that like? Where'd you study for the bar? Which bar did you take?
So people who struggled with a bar hate the way I say this, but because I got fired from that internship, I had to give another full 12 or 15 weeks or whatever to the next internship. So I was a month behind, and I didn't start bar prep until mid-January for the February bar when everyone else, they started it mid-February. I was still in DC and I was taking the Michigan bar because, I didn't really know where I was going to be, but Michigan's where I'm from. So it seemed like a fallback spot where I can take that and just wave into DC and make something of myself there. I did Barbary. I ended up studying a lot at the Starbucks by my house, mainly because I hated it there and I wanted to be in an environment that I didn't want to be in because it would force me to at least study and get out of there. I took an approach that was very risky, but it paid off. If you look at the Michigan bar at that time, I don't know what it is now, you had your 200 multi-state questions, and those were strictly over 6 subjects. Then you had 15 essays 8 or 9 of which were over the same 6 multi-state subjects. And then, your other 5 or 6 essays could be from, 20 different areas. I looked at it and said, well, 75, 80% of my points are coming from these 6 subjects. I'm really only going to study them. And so I just blew off the others. It paid off. I did great on the multiple choice section. I did so good that if it were the year before, I got so many of them right, they wouldn't have even read my essays. They would have just passed me. And they actually give you the essay scores where you can see on, the 8 or 9, however many questions there were on those 6 subjects. I was getting like 8s out of 10s on them. And then the other ones getting like 3s and 4s on them, just relying on what I knew. But it was more than enough to put me over the edge. So I took a tactical decision to focus where the points are. And I didn't sweat a lot of the little things. I think that came from one of the Barbary professors. I forget his name, but he had this story he gave in class where, 3 people somehow brought this lawsuit and they won a Picasso in it, and it was worth 10 grand. And so they each got a third. And he's like, someone once asked me what happens to the last penny, because if you divide 10 grand 3 ways, there's that extra penny somewhere. And the guy's like, I don't know, maybe you flip a coin for it. And the kid was livid with him for giving that answer. But he said, you're not going to get that detail of a question on the bar exam about what happens to the last penny. So you need to know this stuff. You don't need to go into that level of detail. And it kind of helped me know where I should be with my studying. And, ultimately really paid off.
Yeah, thanks for sharing that. I did on a much lesser level, similar thing. I was working full time, and in law school, I never really understood future interests. I just didn't like it. When I would think I would get it, I didn't. So I started talking to people who had taken the bar previously and asked them, how many questions are there on this? I figured it would only come up on the multi-state. And even if it did, there were chances an experimental question.
Yeah.
So I took the calculated risk of just saying, I'm going to guess if a question comes up. I don't remember very many questions. So I was lucky. I don't think the rule of perpetuities or the future interests were on the exam. So it's great to hear a story like yours as well, where sometimes you make a calculated risk and sometimes it pays off. It's often good to think smarter, not harder.
Well, you can spend 2 hours learning that and maybe more. It's probably going to be one multiple choice question. So were you efficient? I don't know.
Yeah. So you passed the bar. How do you end up at the National Rifle Association?
So the mentor I had, who was my externship supervisor, and kind of got a hold of me and said, you are not living up to your potential. You have it. She has connections to the NRA, and she got me a very low paying internship there. I started at like $16 an hour. But then I filed a couple of amicus briefs when I was there, and actually won a couple of cases in the Michigan Court of Appeals and the Michigan Supreme Court, where my briefs were thoroughly discussed, and the content in there was cited in the final opinion of the court that wasn't cited in any other brief. So I was doing pretty good. And, eventually I just rose the ranks and I didn't quit. Won a couple of other really big cases over the years. And very recently, well, not very recently, about 2 years ago, I was promoted to be the division director of the Office of Litigation Counsel. So
So one thing I'd like to point out for the people who do not know you personally is that you are not the person who your haters on Twitter think you are. You're not some gun-toting, insensitive bro wearing a back-to-back World War Champs t-shirt. You're not the poster child for who they think is the human embodiment of the NRA. This is a case of you getting in where you fit in. You found an opportunity you liked, having the ability to present constitutional arguments, and you took it on and represented the interest of your client.
Yeah. My style, I think, I've never been accused of having great fashion sense, but I think I'm a little bit better than the back-to-back World War Champs bro t-shirt. Yeah, that poster child characterization, in whatever you want to call it, it does not really reflect me, and it doesn't really reflect the people that I work with. I work with professionals of all types, not so much of that caricature. And I think one of the places that might come from is people who don't understand other groups tend to just characterize them in certain ways. Jonathan Haidt, he's a psychology professor and an author. He wrote about that a little bit. I think it may also come from, the public advocates out there just trying to discredit people like me a little bit by painting that picture. And, maybe that should have been my answer earlier about what would I tell someone going into law school. It might be the difference between public advocacy and being a legal advocate for someone here, because I think there's a difference in that when you're a public advocate, you can do a lot of things that you can't do as a legal advocate. You can go on the offensive like that. You can, quote unquote, rally the troops, things like that. But as a legal advocate, you're not really the advocate for the cause like that per se. You're representing your client. And I've seen people go down that road, I think, and they get themselves into trouble where they blur the lines between representing their client and representing the cause. Sometimes there's no distinction, but one of the times I think it gets them into trouble is, as legal counsel, you need to be able to advocate for your client and know when to push the envelope for them, but you also need to be able to talk them off the ledge at times. You can't be pulling them up on the ledge and saying, let's jump, especially into a courtroom. That's not going to work. And I see it with a few attorneys I know personally who have told me things like the environment is their client, the planet is their client. They've kind of just anointed themselves with this greater power, and they let themselves, I guess they give themselves license to do greater things or bigger things, not necessarily make great legal decisions. And, there's a group called the Non-Human Rights Project, because I follow wildlife law pretty constantly. And they've brought suits in New York and Connecticut on behalf of elephants and chimpanzees. And they bring these habeas corpus lawsuits saying that these elephants and chimpanzees in these zoos, they're legally people. they're being held against their will. The court needs to declare that they have legal personhood status, legal rights, and they need to be transferred out of the zoos to some other facility that the group approves of. Going into court like that, I think that's one time where you're going to really, really, really try to push the envelope. That's something where I think you need to have a discussion with your client beforehand. Another area I think you see a little bit of that too, at least on the prosecution side, is when some of the prosecutors out there, they have this crime, they have to solve it. They won't let facts or evidence get in their way. They'll just grab someone and build a case against them rather than trying to find out who actually committed that crime. And it doesn't help anyone there because they've now prosecuted the wrong person. The person who committed that crime is still out there and there's no justice there. So that's where I think you have to understand the difference in that with legal advocacy, you're representing your client first and foremost, and you have to look out for their best interest, not necessarily the greater good. They don't always conflict, but there are times where they will, and you might set some really bad precedent, like the guy in New York and Connecticut just did. So
I see. So step one, you're saying, is recognize that there is a right out there that belongs to your clients, and then advocate in the best interest of your client.
Yeah, if you make it about something much bigger than what it is, I think it's hard to stay focused in the court. Justice Breyer said this a while back. I forget the name of the case, but it was about a discrimination case where someone was dismissing all the members of the jury who were the same race as the other party. And, if you can make it about a grand issue, but I guess at oral arguments in that case, the counsel said, this person, my client, they went in to do their civic duty and serve on the jury. They went in there with the expectation they would not be discriminated against, and that's exactly what happened. Justice Breyer picked up on that, and he said, that's the tone of the opinion I'm going to write. Kept it simple, focused on the facts. And that's not only that does it help you stay focused, but that's what courts are there to do. They're there to arbitrate cases and controversies. So I think focusing on the facts of the case is something that they would prefer more too. Otherwise, it's really hard to stay focused on the case at hand. And, you're also, I think, trying to do something that you shouldn't really do, and you'll end up showing off. It'll come to get you in some way. You'll end up stepping in it somehow.
Okay. So let's talk about the NRA. And for those who don't know who the NRA is, as I understand, they're a civil rights organization. They focus on protecting gun rights and the Second Amendment, those sorts of concepts. And what would you have to add to that?
Founded in 1871 by some Union generals. The original mission was to promote firearms marksmanship amongst the people. And my understanding of it is that when the Civil War broke out and it was time to get everyone ready to go, marksmanship was something that was lacking, and it took a lot of resources to train people. So it was originally founded to really study and focus on marksmanship. Over the time, it branched out into other areas that go hand in hand with that. I also am told that we wrote the first ever hunter safety manual, and went on to begin advocating for the people's Second Amendment rights. So primarily, its advocacy mission is to defend the people's Second Amendment rights and defend our hunting heritage. But we also have probably more other divisions than I can count. There's membership divisions, there's education and training divisions, there's a law enforcement division, there's a publications division. So do a lot of things.
So what is your role within the NRA?
I am in the NRA's Institute for Legislative Action. That's the lobbying arm of the NRA. We handle all the political things. My specific role as director of the Office of Litigation Counsel is to advance our members' rights through litigation and advocacy. I was doing more litigation directly in the past, but then you get promoted to being the director and you become more of an administrator. Now I describe myself more as kind of like a head coach, where I kind of put together a game plan, look at places where I think we can get some wins, and see if we can execute those in that way.
So, as I understand it, it could manifest itself in many different forms, but a law gets passed by state legislature, and the NRA feels that it is infringing on the Second Amendment rights. So then your team would get involved to challenge this law, therefore advocating on behalf of those Second Amendment rights. Is that an accurate assessment?
That's pretty accurate. It could also be a federal law, local ordinance, an agency action, but for the most part, that's pretty accurate.
And who decides that this is worthy of being challenged?
That's a decision that I make with leadership. So we look at the law, whether we think we have a winnable case. And the thing there is, not every case is winnable. Litigation can't solve everything. So that's primarily what we're looking at. We have to set our priorities too. We can't do everything at once. So it's basically, I'll take an assessment of something. We'll have a discussion. We'll get other people's voices if we need it. And ultimately, we'll either proceed with it, or maybe we won't. We'll put it on the back burner and come back to it later. But we're always looking for ways to advance our members' rights that way.
And I assume you're believing that there's legal grounds to challenge, right? You're not just opposing any sort of legislation that gets passed.
Yeah, that's, again, the difference between legal advocacy and public advocacy is, in order to be successful in legal advocacy, you need a legal theory that you can win on. So that's what we're looking at. We're looking at precedent. We're looking at where the trend in the courts are going. What are the best ways we have to challenge the law at issue, and if we think we can be successful there. And
so let's talk about a headliner.
All right.
It caught a lot of people's attention. New York Pistol v. Bruen, as it's called casually. Then Roe v. Wade got overturned and sort of overshadowed, but in terms of gun advocacy and that realm, it's landmark case. Tell us a little bit about this case. This is my loose understanding of the facts. We had a guy, Koch, and another guy, Nash, two parties, that they were allowed in New York to carry weapons for target shooting and hunting, right? But they wanted an unrestricted license. And then the New York gun licensure regime had a requirement that they had to demonstrate a special need to own this gun, right, for that purpose. So they challenged it, believing that their rights were restricted, and the litigation ensued. Is that a high-level view of the facts that led to the subsequent litigation?
I would say that's a pretty accurate high-level view. I guess giving a little legal background here, in 2008, there was Heller v. District of Columbia. That held that there is an individual right to keep a firearm in the home. Then in 2010, McDonald v. Chicago, that held that the Second Amendment is a fundamental right, and it applied to the states through the selective incorporation process. After that, though, the Supreme Court goes pretty silent on the Second Amendment, and there was a lot of litigation over a lot of issues. The one area in particular is, Heller and McDonald both involved keeping a firearm in the home. To what extent does the Second Amendment apply outside the home via, the word keep and bear? There's two verbs there. So that's what this case was ultimately about. And New York was one of, I want to say, 7 or 8 states in DC over time that had either a may issue regime, meaning if you want to get a concealed carry license, the state has discretion to give it to you, or they would have something like New York's proper cause or good cause or justifiable need requirement, where you would have to show that you had some special need to get your permit. Now, these have been challenged a lot over the past. NRA was successful in challenging Illinois in the 7th Circuit and DC's in the DC Circuit. These restrictions, though, were ultimately upheld in the 9th Circuit. The 1st, 2nd, 3rd, and 4th. So we had this circuit split, and we decided that we were going to take the issue. So we launched a campaign of cases. We challenged New York's, we challenged New Jersey's, we challenged Maryland's, we challenged California's. These cases all start moving. They all get up to the Supreme Court at about the same time that another case of ours in New York got certiorari granted in it, and that was New York State Rifle and Pistol Association versus the City of New York. New York had this regulation that said, if you want to get a concealed carry license, the state has discretion to give it to you, or they would have something like New York's proper cause or justifiable need requirement, where you would have to show that you had some special need to get your permit. Now, these cases all start moving. you can have a firearm, but you can never take it out of the city, and you can only transport it to, one of our half dozen or so ranges in the city, and that's it. You can't go anywhere else. So that was where we thought we were going to get to the outside the home issue. After defending that ordinance very vigorously, cert gets granted and New York City repeals it. New York State then goes ahead and passes another law that says New York City can never reenact the ordinance again. So it's now, fully mooted, as the court ultimately ruled. That happens. And then there were about 10 Second Amendment cases up at the Supreme Court in June 2020. We had a couple of our carry cases up there. Everyone's excited about it. They think the court's going to take one of these cases now. But the term comes to an end and they don't. That kind of set everyone back a little bit. And I think it was interesting because to get cert, you only need 4 votes. And at the time, Justices Alito, Thomas, Gorsuch, and Kavanaugh had all indicated that they wanted to take a Second Amendment case. They wrote it in dissents and elsewhere. If they wanted to take any of them, they could have, but they didn't. And then you start to think, well, okay, are they not sure about where the 5th vote is on these cases? And then you think about it a little more, and you think, oh, well, the 4 justices on the liberal wing of the court at that time, which would have been Breyer, Ginsburg, Sotomayor, and Kavanaugh, they could have easily just granted it to and ruled against us if they had a 5th vote. So the consensus at the time was no one knew where Chief Justice Roberts stood on the issue, because if anyone did, they would have just taken the case and cemented their position, but it didn't happen. That happens. I have this other case out of New York, and trying to think, what are we going to do with it? The court just said, we're not really interested in any of these cases. But that circuit split was there. Too important of an issue for them to ignore forever. So we pressed on and we got cert. One of the interesting things that happened there is when you petition the court for certiorari, you ask a specific question, and your opposition will try to reframe the issue and put their question in. The court will ultimately grant a specific question that it's going to answer. In our case, it was whether the denial of the petitioner's permits violated their Second Amendment rights. We go ahead and start briefing the case, have a ton of amici file briefs. Then New York goes and files their brief, and they try to change the question. They ask, whether those conditions they put on it are, necessary to protect the sensitive places. And that was a telling fact too, because Justice Thomas has said this in the past. Once we grant cert on a question, no one has any license to change it. But by abandoning that question and trying to frame the issue elsewhere, it suggests that, you think you're very weak on the question the court wants to ask. So they focus their briefing that way. Ultimately, though, we have a pretty good oral argument. And, in June, we got one of those landmark rulings that changed the entire scope of this field of Second Amendment jurisprudence, because not only did it answer the inside the home, outside the home question, it also gave us a new test to apply. So it will be one of those cases that get read about in law school case books.
So let's talk about the new test. I know a lot of the opposition has criticized it. And what they've said is, among a lot of other things, is that every other fundamental right is subject to some sort of balancing test versus the governmental interest, right? So if you're going to regulate free speech, for example, you would balance that against what the governmental interest here. So in this case, you'd have Second Amendment being in question versus the governmental interest, which would be public safety or regulating in firearms. So how did the Second Amendment have an exception to this rule, whereas the other rights don't have to undergo that balancing test?
Yeah, a couple of things. One, the Second Amendment preserved a pre-existing right. It did not codify a new right, so we have to look at the history behind it to determine what it is. That's not necessarily the case with some of the other amendments. They conferred new rights. Two, I don't think that all other rights get their interest balanced is a true statement, in that, with content-based speech restrictions, you start out, it's presumptively lawful. I find it hard to believe that you would be denied your right to a jury based on interest balancing. I think that's one of those rights where you just have it. There's no amount of interest the government could have to take away your right to a jury, or some of your other rights in the criminal justice context, like your right to counsel. If your right to counsel exists at a certain point and you don't get it, it's an automatic reversal. I would also say that our rights themselves are the product of interest balancing, in that by putting them in the Constitution and preserving them, the people said what their particular interest is. And I guess a final point I would say is that over the last 12 years between McDonald and Bruen, the lower courts pretty much showed that they were unwilling to do any serious probing on the interest balancing test. In the first New York case, NYSRPA v. New York City, challenging that ordinance, New York defended that ordinance on public safety grounds for a long time. Then we get cert, they repeal it. At that argument, their counsel was asked if the people were less safe without that ordinance in place. And their counsel said no. They're just as safe now as they ever were, which means it was never necessary at all, and it did nothing to promote public safety, despite the Second Circuit's conclusion to the opposite. And at that argument, I even remember Justice Ginsburg jumping in at one point and saying, that the ordinance absolutely didn't promote safety, because now people are leaving their other firearms at their other homes unattended, and that certainly, according to her, doesn't benefit anyone. The Ninth Circuit, too, is a good example. They were 0 for 50 on the Second Amendment. It might even be a little worse now. But every case before them, the Second Amendment lost. There were, I want to say, 5 or 6 panel decisions where we got good rulings from panels on cases, and en banc review was automatic. They always granted it. They would grant it in a matter of weeks, and the outcome was always reversed. And I think one of the cases you can point to there is Teixeira or Teixeira, if I'm pronouncing it right, but he was in Alameda County and he wanted to open a gun shop. He went to get his permit to do that. It was denied. He challenged that. The Ninth Circuit says, public safety requires denying this permit here. So the county's action was just. They have this public safety interest, and the infringement on where this gun shop is going to be located is, not too bad at all. The problem with that, though, is at the zoning hearing, when he applied for that permit, they made a finding that granting him the permit to open that gun shop would have no adverse effects on public safety. So they came to that conclusion despite everything in the record saying the opposite, which Judge Bay pointed out in her dissenting opinion there. So I think that's another clear example of the way the courts were interest balancing over the last 10 years. There was no balance at all. It was just, can the state save public safety? And if so, they win. And, the $1 million question we'll never know is if they applied some more demanding types of scrutiny, would the Supreme Court have gone in that direction? I think they probably would have, because Justice Kavanaugh was one of the first to use the text, history, and tradition test back in 2011. But, you never know if things happen differently. And that's the way it played out.
Yeah. So in terms of this new test, let's talk about one thing. So what I understood in Clarence Thomas's new test is that the only thing that matters is whether the regulation is the type of regulation that would have been acceptable at the time of founding. And as we know, or as we may know, like at founding, there were some regulation at polling places, schools, that sort of thing. So what do you say to the opposition that would say, look, you're focusing on the type of regulation, but you're ignoring the type of firearm? So if you want to take your musket to the Eagles game, I'm more willing to understand that line of reasoning versus the nature of firearms have changed. They've become more destructive. What do you have to say to that?
If you take a musket to an Eagles game, they might think you're a Patriots fan. And I don't know if that's a good idea for you or not. But in Heller, the court called that argument, I think, borderline frivolous. And that technology argument, it fails in all other contexts. Under the First Amendment, if we're just looking at the types of communications that were available in 1791, then this podcast wouldn't be protected. The government could come here and censor whatever we were saying, or restrict whether we could say it at all or not. I guess the only types of communications that did really exist were local papers and books, and maybe the town crier, if you want to be that guy. In the Fourth Amendment context, your right to privacy, or your right to be free from unwarranted searches and seizures, now extends to wiretaps and phone calls and emails and texts and all kinds of other forms of communication and technologies that did not exist in 1791. So ultimately, you have a right that's established in 1791, and it generally protected the common methods of communication at the time, the common firearms at the time, and with the Fourth Amendment, your person, your papers, your house, your common possessions at the time. So it's not limited to those things technologically. You come now in the 21st century and say, are these common forms of communication that the people would have thought would be protected? Are these commonly owned firearms for lawful use that are protected? And are these common possessions that the people hold, or that should be protected under the Fourth Amendment? Things of that nature. So that's why that technology argument doesn't really hold up in other contexts.
In terms of the Constitution, would you say you're a constructionist? Would you say you believe in the living Constitution? Where does your ideology lie?
Pre-law school and during law school, I would have probably said a living Constitution, because that's the only thing that I was taught. But I think Justice Scalia makes the case much better than others that the Constitution meant what it meant at the time, and there's a provision to amend it if it needs to mean something else. One of the anecdotes that I think really settled this for me is the word Nimrod. Do you know what it means?
I know it as an insult that you would give to somebody.
Yeah, there's a specific reason you know it that way. Nimrod originally meant a hunter, and there were restrictions in place that said Nimrods must carry a license. But if you grew up watching Bugs Bunny, who called Elmer Fudd a Nimrod all day long, you would think a Nimrod was an idiot, not a hunter, because Elmer Fudd was both. So if you're going to change words over time, you've now, thrown out those original statutes, and now hunters don't carry a license. Stupid people carry licenses. I think that's a huge problem with it. Two, there's a very specific place for process for ratifying the Constitution, and only those people involved in that process had an idea of what they were ratifying. You get into more problems when you say, well, it changed its meaning at, when subsequently did those provisions change their meaning, and how? Is it popular opinion? Again, if popular opinion says that we need a new right or to amend something in the Constitution, we're supposed to amend it. Scalia rightly pointed out that it's very hard to do so, and he would make it easier to do that. And I think third, it's very undemocratic to have a system where 9 justices get to say what the Constitution means based on the way the wind is blowing at the time. And I think you see this a lot in other countries where judicial activism is the standard. It happens a lot in Latin America. It happens a lot elsewhere. But we have our separation of powers here. So when the people want something to be reflected in that Constitution, it's up to them to make it happen. And if they didn't want it in there when they ratified a particular clause, I don't know how we just say and change the original vote that happened based on popular opinion of the day.
So let me ask you this, and this is something I feel is very important for people to understand. You always hear grumbling and anger towards the Supreme Court when holdings come out one way or another. And the biggest misconception, I would say, even within lawyers, they seem to want the Supreme Court to do the right thing, quote unquote, the right thing, which amounts to enacting law, which is not their function. Mm-hmm. Theoretically, the Supreme Court should be angrily like certain justices should be angrily writing an opinion that annoys them, but based on the Constitution, they are doing their job, interpreting it properly, and either enacting the law or striking down the law. What would you have to say about the Warren Court and all the changes that took place with regard to the Fourth Amendment? Was that court enacting law and not doing what they should have? Or would you say that they were still operating within as a constructionist?
So with the Warren Court, a lot of Jeff Sutton talks about this in his book. A lot of those decisions they made had percolated throughout the state courts first. Things like the exclusionary rule, that became very common amongst the states to the point where, it was prevalent at the time, not necessarily the prevalent view at the Supreme Court level, or it may not have been at the time of the founding. But I think a lot of those rulings were ultimately good for us. I don't know how strong they are and how defensible some of them are,
So what you're saying is, like, ultimately they quote unquote did the right thing, right? These are rights we should have. But theoretically, you think a lot of constitutional scholars would look at what they did and say, no, these changes should not have flowed down from Supreme Court holdings. They should have been passed through new legislature, through amendments to the Constitution, et cetera.
I do think that.
And sorry to interrupt. I think that's a distinction that people don't understand. They think a justice is dumb. They think a justice is this. When we were getting appointing justices, and I'm like, look, if you want your cause to get passed, just say that. Don't say they're not doing their job or they're doing the wrong thing, because I think to reach that conclusion, you really need to understand the constitutional argument on both sides.
Well, one, it's undemocratic that these 9 appointed people can
for life, right?
For life can do that. 2, I think the separation of powers is very important in another way, and that's, if you want to protect your rights, the best way to do that is to divide power up so no one has it all. And you see this again in some of these other countries. The prime minister is a member of parliament. They appoint him when they're not happy with him anymore or her. They have a new election and they don't have the autonomy to really do what they want. uh, again, in Latin America, and there's a judge on the Supreme Court of Israel. I think his name was Barak. He gets picked on a lot for his statement was that something like the law is everywhere, so therefore my reach is everywhere. And he famously decided a case where he thought that it was unreasonable for the military not to distribute gas masks to people in Israel and force them to do that. That would never happen here. The president is the commander in chief, gets to decide what to do with military resources. So, but that's where I think the separation of powers is very critical. And I think a lot of people don't. But you do have every right to say there should be this law, and you should advocate for the laws you think there should be. It just doesn't necessarily mean they were enshrined in the Constitution hundreds of years ago.
Yep. And would you agree, like, perfect example of that? I don't know enough about these, but like some of the civil rights legislation was passed through amendments. There were Supreme Court cases that failed because maybe the Supreme Court was saying, look, our founders were racist. They didn't give these rights to other parties. And therefore, through subsequent amendments, that's how these parties got their rights that they ultimately should be entitled to.
Well, I think the one thing there is it wasn't until 1896-ish that any provision of the Bill of Rights was applied to a state, and that was the Takings Clause. And it wasn't until the 1920s that the First Amendment got applied to the states. So there were no federal rights that applied to the states at the time. So going to the Supreme Court with your case, there was no option for you there.
I see.
It may be unjust, but that was the system.
Yep.
We've now incorporated, there may be one or two clauses in the Bill of Rights that still aren't there. I think the jury's fees thing may not be incorporated yet, but I think most of everything else is.
Okay, for this portion of the program, I like to call it Explain It to Me Like I'm a 4-Year-Old. You ever seen the movie Philadelphia with Denzel Washington, Michael?
I have seen it.
It's my favorite line. I use it all the time, and I think it's perfect. Normally, I have my guests come equipped with something ahead of time, but I have the perfect one for you, so I'm going to put you on the spot here. An assault rifle. We hear that term thrown out in the media all the time, and it has a very negative connotation to it because of the damage that it can inflict. But I think there's some intricacies to that word, and I would like you to explain to the audience, what is an assault rifle?
Well, I will do my best to explain that term to you like you are a 5-year-old. It's a difficult term to explain because it is a made-up term and it doesn't have a uniform meaning. So this will be my legal disclaimer here. Check your state law because this may or may not be relevant to you whatsoever. When you look at what an assault rifle is, Congress and some of the state legislators had a very hard time defining it. So we end up with two different tests that kind of pop up in places, and there are a lot of variations throughout them. The first one being a model test and the copycats or the copies. So the law will list several different makes and models of firearms and say these are quote unquote assault rifles, and so are their copies. That gets very problematic because, when does the Colt AR-15, which is usually among those listed, stop being a Colt AR-15 and become something else? It's very difficult to tell, mainly in part because assault weapon or assault rifle has no standard meaning. So then you get into the other test, which is what's known as a cosmetic features test. The rifle will need to have a certain number of the enumerated features on it in order to be what the state would determine, would call an assault rifle. The common ones here are going to be a pistol grip, that is a vertical grip, like most pistols have, instead of a horizontal, more straight flowing rifle grip that is more common on a lot of the rifles. That doesn't really do anything except it changes how your hand is held when you shoot. Another common one is going to be the folding or telescoping stock. The stock is the part of the firearm that rests up against your shoulder when you're shooting. Some of them will fold in and out. Some of them will telescope in and out. And that's mainly for storing them in different places. Beyond that, there are several other features that have been thrown around in these things. One of them being the bayonet lug and whether you can mount a bayonet to your rifle or not. Some of them have a grenade launcher attachment, which is an odd thing because grenades and grenade launchers are destructive devices under federal law, and you can't possess them at all. Some of them will incorporate other features like a protruding vertical forward grip. That's similar to the pistol grip, only it's where your left hand, if you're right-handed, would go and you would hold the firearm vertically with your forward hand. You can get into others. Some will include a flash suppressor, muzzle brake. These are all, technical terms that don't really affect the rate of fire because regardless, you're working with a semi-automatic rifle, you will be able to shoot one round with every pull of the trigger. It has nothing to do with the bullet or the cartridge itself. There are several other higher powered cartridges out there. A common example would be the 30-06, which is probably taken more deer than any other cartridges out there. A lot more powerful than the round that's used in most quote unquote assault rifles. So what you ultimately have is a list of cosmetic features that you need a minimum amount of, and they don't really affect the rifle's capacity at all. It's just where your hands are placed when you hold it, how you store it, things like that.
Okay. So thank you for that explanation. What I get from that is that when someone's banging the drum, someone who doesn't have knowledge of arms is banging the drum to ban the assault rifle. Often what they're not really understanding what they're saying because you're talking about cosmetic features. And by just saying ban the assault rifle, you're not addressing the impact necessarily that the gun could cause. Is that correct?
That is correct. Like I said, there are a lot more powerful cartridges out there that are used to take deer with all throughout the deer season. So it's strictly and I think that's the problem that Congress and some of the states had when they were trying to regulate and ban these things. It's, well, we don't want to totally, get rid of our deer hunting population, our deer hunter population and the rifles they use. But we can't really regulate these things in any other way. So we're just going to look to these features that, make quote unquote assault rifles different. But they're not really based on capacity at all.
Yeah, I think it's good for people to, whatever side of the hot topic that they are, to equip themselves with sufficient knowledge, because to truly be against something, you should truly understand the opposing side and truly understand all the facts. There's so many issues like this where I sometimes pull my hair out because I feel there's so many omitted facts that the general public doesn't seem to understand. One thing that comes to mind is student loans, the whole student loan crisis. I think the average person thinks that it's out of hand, that it's unfair, all sorts of things. I wrote this very lengthy blog post when the relief came out, saying actually the government, I believe, has already done enough and a lot for us, and they're continuing to do more. What people are not realizing is that, yeah, you can't file bankruptcy on your student loans, but they've kind of, with this income-based repayment, created something analogous to a Chapter 13 bankruptcy, and that doesn't impact your credit. And they offer also debt forgiveness if you go into public service, or debt discharge after 25 years. I think it's gone down to 20 and then eventually 15. So a lot of people aren't aware of these facts, and they're just jumping on a bandwagon without fully understanding the issue.
Sure, I think that's very accurate with the student loan example you said. And I think a lot of people feel harmed by it. Someone made this example where, a plumber, why shouldn't someone pay off his truck because he took out a loan to buy the truck instead of going to school? I think you also have the moral issue when you get into it, and that the people took on that debt, they have a moral obligation to repay it. And then I think you have to look at the higher education system too. It was, if I'm not mistaken, the St. Louis Fed a while back that did a study, and whenever the federal government increases the amount of student loans available, tuition at universities goes up, I think at a 0.6 ratio. So it's predictable, just like clockwork, that they had some responsibility to blame here.
Yeah, I addressed that in my article as well. I said that if you look at the rising cost of tuition and textbooks, they exceeded the cost of inflation and all sorts of things that you could tie to within a 20, 25-year period. And that these institutions realized that they had a piñata on hand with this federal funding and would continue to whack the piñata, continue to build things that didn't need to be built on campus, Olympic-sized swimming pools, high dives, all these sorts of facilities. And that ultimately impacted the sticker tag of the students. It's not really the government's fault. The government was just trying to keep everyone that wanted to go to school and give them the opportunity to do so.
Yeah, I mean, going back to our alma mater, my first term, I remember tuition being about $960 a credit. And when I left, it was right around $1,300. That's a 30% increase in 3 years. The service didn't get 30% better. The market at that time certainly didn't reflect higher wages that could support that increase in tuition. So,
yeah, and what did get 30% better? The facilities did, right? So they opened up new buildings. I remember they built a very nice annex to the library, and where we could bring food in and eat after hours, and they opened up additional campuses. And hey, look, at the time, enrollments were at an all-time high, and it appeared everyone wanted to go to law school, so they were giving people those opportunities. But for the people that started there, we weren't getting what we wanted out of it, and we were paying higher tuition costs for it.
Yeah, I remember that annex to the library. It was open 24 hours, and I definitely pulled some all-nighters in that thing. So yeah. I guess it helped me.
It wasn't nice to have. I'm not gonna. Cooley didn't have to take that one back. That beat having to go to East Lansing and hit up the Michigan State Library because that was open 24 hours. And there was always this population of students that felt too cool to study at the Cooley Library. So they would always go to the East Lansing Library, either because they didn't want to be seen, or I don't know what the whole deal was, but I don't know if
I remember some of those people. Yeah. I never figured that out.
So
hey, it worked for them.
Yeah. Well, Michael, I really appreciate your time coming on today, opening up and telling us about your journey, how you came into the position that you are, how you've grown, all your insight into constitutional law, all your thoughts on gun reform and the constitutional theory. I think people that are very in favor of protecting the Second Amendment have a lot to take home. And I think people that are very much in favor of gun control maybe have some additional knowledge that they can unpack after hearing this episode. So I really appreciate your time.
Of course. Thanks for having me.
All right. So to my audience, stay solid, and Piano Man, take us out.
Need a lawyer? Are you having financial, criminal, or family challenges? Call or text the Mark Kachi Law Firm, 215-439-7899.